Listen, oftentimes many people ask, what is the statute of limitation of particular debts and when debt collectors can no longer sue? This is a question that I get a lot on a video where I break down how to communicate with debt collectors that puts you in a position of power. So down below, I want you to put what state you're in so you can connect it to exactly what your statute of limitation is currently based on whatever the debt type is, because it's based on what state you're in, number one, and what type of debt is it. Is it a credit card or open-ended type debt? Is it, installment loan? That determines what your statute of limitation is and how long they have to sue. And this puts you in a position of power because once you know this, now you are not threatened by some of the things that they do. They have a lot of unlawful, threatening type behavior, and they're just trying to scare and fearmonger you into doing certain things. This is not to say don't pay your bills. This is not to say don't do, what you agreed to upon the initial agreement. This is basically putting you in a position of protection if you fell on particular hard times that led you down the path of collections, etc. So let's dive in. Now, what is the statute of limitation on my credit card debt? And it's going to break down more than just the credit card debt. Again, drop what state you're in down below so you can connect it to what state you're in, and I'm going to show you exactly how you need to navigate. The statute of limitation for credit card debt is a law limiting the amount of time lenders and collection agencies have to sue consumers for non-payment. So once it's gotten beyond that, then they can no longer sue. And this is applicable to lenders and collection agencies. That time frame is set by each state and varies from just 3 years in 13 states to 10 years, 2 states, with other 25 states somewhere in between. The purpose of the statute of limitation for credit card debt is to prevent creditors from taking consumers to court long after evidence of the debt has been discarded or disappeared. If the lender or debt collector wins a court judgment against a consumer, it opens the door on several options for collecting the debt, including wage garnishment and seizing property. I'm going to repeat that. If the lender or debt collector wins a court judgment against the consumer, then it opens the door of several options for collecting the debt, including wage garnishment or seizing property. Now, if you found yourself being sued or summoned, I need you to comment below and find out how to reach me on other social media platforms, because it's just Mr. and Mrs. Smith Official across all platforms, because I have a solution that can position you to not get your checks garnished or not even lose the lawsuit, because a lot of times they have some unlawful practices and behaviors that cause them to violate your rights. But if you don't know and you just go in naked or not, protected, now you position yourself to lose, which can lead to them collecting the debt, wage garnishment, seizing of properties. And that's not what we want. Now, what is the statute of limitations on debt? The statute of limitation is a state law that sets the deadline for the amounts of time that parties must initiate legal proceedings against someone for unpaid debt. The law does not eliminate the debt. It merely limits the time frame that a creditor or collection agency has to take legal action to collect it. The time frame varies from state to state, but it is generally 3 to 6 years. And it most often arises in civil matters where consumer debt is considered time barred, meaning that statute of limitation has expired. Legal actions and threats of legal actions are prohibited when the case is time barred. So once it's been time barred and beyond that time frame, then it's prohibited. When legal actions try to arise, they're out of their time frame. Nonetheless, consumers should not consider the statute of limitation a get out of jail free card. That's important to note, because sometimes people do, but it is still good to have at your advantage and to know how to operate if they're trying to sue out of that time frame, which many of them do, or they're just trying to get you to pay a little bit. They don't care if you pay $1. They say, hey, you can just pay $1 on it and, we'll slow it down or leave you alone, or whatever they use to get you to reopen that case because you've initiated a new payment. So be careful and mindful of that, because that has been the thing that dug people down the hole. They were right there outside of the statute of limitation. Then, they got enough calls and they're like, okay, I'll pay $1, $5 and, start working with them. And now you just reopen the case. So That's very important to know. But it's not a get out of jail free card. You still owe the debt, and the collection agency has the right to pursue attempts to make you pay it. They just can't take you to court over it. Now, I have to interject right here because it says you still owe the debt, and the collection agency has the right to pursue attempts. They can pursue attempts, but they do that when many people don't understand their rights. Now, when a collection company is trying to collect, what you want them to do is validate their debt, that alleged debt. Very important, alleged debt, because they haven't proven anything. They're just collecting based on this big bulk of debts that they've purchased. Didn't go into an agreement with you. You didn't sign anything. You don't know what that account is that popped up because it's like, hold on, who is this? What is this company? So they didn't go into agreement. But I also want you to make sure that you get the assignment of debt. This is them proving that they have the legal right to collect on the debt because it was assigned to them by the original creditor. Most of the time, they don't go through the proper measures, answer the proper questions, and do the things necessary in order to address it from this angle, which puts them in a position where they don't have the legal right to collect or pursue attempts for you to pay it because they dropped the ball, did some things unlawfully. So this is very important. So I know it says they have the right, but if you know your rights, or you have assistance with the debt collection process, or having somebody working on your credit, whether it's us or someone else, now you position yourself to use the laws to your advantage to prove that they did some things unlawfully, whether you quote unquote owed the debt or not. But you position yourself to not be taken advantage of. So types of debt. The statute of limitation can apply to criminal or civil proceedings, and laws and time limitations vary from state to state depending on the severity of the offense. The statute of limitation most often comes into play in civil law cases involving borrowing and lending. There are the types of debts where the statute of limitation is involved, or these are the type of debt where the statute of limitation is involved. So open-ended debt. So what is an open-ended debt? An open-ended debt is a term for any loan that does not have a definite end date for repayment, such as a credit card or a line of credit. We call this revolving debt. It's open debt, because you can use the money, pay it off. Use the money again, pay it off. Use the money again, pay it off. Unlike a loan, which we'll dive into. But the borrower can draw on the loan as many times as they wish, up to a pre-approved amount. Written contract. This is a printed agreement between a lender and borrower stating the amount of money loaned, interest rate, and fees for borrowing and repayment terms. Oral contract. This is an agreement that is spoken but not put in writing. It is considered legally binding by proving its existence, but proving its existence can be difficult. So a contract can be oral, can be written, where it's printed agreement between the lender and borrower stating the amount of money loaned. Easier to prove. Oral contract, harder to prove, but it is a form of a contract. And then a promissory note. This is a written promise by a borrower to pay a specific sum to the lender by a specific date. The lender doesn't necessarily have to be a bank. It can be a friend, relative, or the company someone works for. So all of these are debt types and agreements. Every state has its own statute of limitation for each type of debt. Written contracts and promissory notes have the longest timelines because they're most easy to prove. A written contract and a promissory note are most easy to prove, so it has a longer time frame, even more than an open-ended credit card debt. Now, let's talk about the statute of limitations. The statute of limitations for each state in a number of years. It is important that consumers understand the statute of limitation. Laws vary depending on where you live. Drop your states down below. For example, Massachusetts, Connecticut, Maine, Vermont have 6-year statute of limitation for credit card debt, while neighboring New Hampshire is just 3 years. So some people don't have that long before these companies can no longer sue. So you might have even more pressure being applied in between the time frame because they know they don't have as much time. Here's a chart showing the statute of limitation for all 50 states plus Washington, D.C. So get your screenshots or write down wherever you fall so you can see what it is currently. This changes from time to time, but this right here is updated in 2025. So this is more accurate. But you got Alabama, Alaska, and Arizona. And if you look across the top, you'll see written contracts, oral contracts, promissory note, open-ended accounts, including credit cards. And that ranges from 3 to 6 years across the board, depending on which account type it is. Let's keep going. Arkansas, all the way down to Connecticut. This ranges from 3 to 6 years as well. And keep in mind, the credit cards, which many people are asking about, is on the far right side, because I know it's not showing the actual labels. So just remember that the credit cards is on the far right side. The promissory note and written contracts are, the first and the third. So just keep that in mind as we proceed. Got Delaware. Get your screenshots. If you find your state, get your screenshots ready so you can take a picture and see exactly where you are. Hawaii to Indiana. Now you're starting to see some tens. So Illinois and Indiana, they're not playing about the promissory notes and the written contracts. As you can see, they have a decade to sue during that time frame. Then we got Iowa to Louisiana. Louisiana definitely not playing across the board, including oral contracts. 10 years across the board, and then 3 years for the credit cards. Then we got Maine to Michigan. Get your screenshots ready. Drop your state down below. Minnesota to Montana. We see some 10s. We see some 8s. Minnesota 6 across the board. Then we got Nebraska to New Jersey. New Mexico to North Dakota. Get your screenshots ready. I'm just pausing briefly. Ohio to Pennsylvania. Rhode Island to Tennessee. So Rhode Island not playing. With those credit cards, they like, hey, we got 10 years to sue for these credit cards. The written contracts are only 4. I say only just because compared to 10, it looks like only. Then we got Texas to Virginia. Texas is pretty, consistent across the board with all 4s. They're pretty lenient. They're like, hey, if you're going to do it within 4 years, and then leave them alone. Then we got Washington State all the way down to Wyoming. Not to be confused with D.C. And these are the dates. Now, the debt doesn't expire simply because it wasn't collected in the time frame set by the law. The consumer still owes it, and debt collectors have a right to pursue it and make negative reports about it to the credit reporting bureaus. This is just one of many nuances in the statute of limitation law. Here are 10 more nuances and that you should know about before determining whether it helps or hurts your situation. So after moving, which state laws or debt statute of limitations apply? This is a really good question for those of you who have moved. The first thing to do is check the agreement you sign with the credit card company. Many card arrangements have a clause in them called the choice of venue. That dictates which state court will preside over any conflict. Now, this is beneficial if you're in a state like Louisiana or, somewhere that has a high statute of limitation across the board, and now, or Rhode Island, basically, with the credit cards and et cetera. And now you move to a state like Texas, that has lenient law. This could be a benefit. But typically, card companies or debt collectors want to file the case in whatever state they have the most advantages. State with the longest statute of limitation, state where courts have sided with creditors, but you can argue against any of them if you have a compelling case. Bottom line here is this can be a tricky question, and may require you to check with a consumer lawyer in your state. And when does the statute of limitations start? This is a great question for those of you who made it to this. Then you're able to see when the statute of limitations starts. The clock starts the date you make your last payment and runs for whatever time period is applicable in your state. And this is why I said sometimes they can get you to restart the clock just by making a payment. That's what I meant by that. So if they get you to pay $1, reset, they just reset the clock by allowing you to reopen it because you agreed to pay what you consider to be, a small amount of work towards paying out the debt. So the clock starts the date you make your last payment and runs for whatever time period is applicable in your state. If, for example, you haven't made a payment on your credit card since January 2021 and you live in California where the statute of limitation is 4 years, the statute of limitation expires January 2025. If at any time in between you got tired of debt collectors harassing you and decided to make just one payment or sign an agreement to make a payment, the clock could start again on that date. Remember I said that. Check the laws in your state to find out how long the statute of limitation applies and whether payment of any kind restarts the clock. Can debt collectors contact or sue after the statute of limitation periods end? This is the good question. Yes, debt collectors can contact you after the statute of limitation has expired. You still owe the debt, but remember what I said, make them prove and validate and show assignment of debt. They're saying you still owe the debt, and if you don't respond, the debt collector could still sue you. However, you can present a successful defense that the statute of limitation has expired, holding them accountable. They'll take advantage of you if they know you don't know. If you show up for the court hearing, that if is in caps because many consumers don't appear in court. Either they don't check their mail to see the court date has been scheduled or simply ignore the summons to appear. If you don't show up in court, you lose. Case closed, a judgment will be awarded against you. So it's a default judgment basically because you didn't show up. So they just assume that whoever did show up was right. And now they go ahead and pursue. So you don't want to ignore this. You don't want to not go to court. You want to seek assistance because I told you I got a partner who's able to prove in many cases and has helped tons of people across the nation, hey, y'all did this unlawfully, and then sometimes people get a check. They get paid because of the unlawful behavior of these debt collectors. Now, let's wrap it up. What does time-barred debt mean? A time-barred debt is a debt that is no longer legally collectible because the statute of limitation has run out on it. It also is the name of the defense you would use if a debt collector tried to sue you after the statute of limitation on your debt has expired. So basically, you'll say, hey, this is a time-barred debt. The judge know what's up. They know what that means. And now the debt collectors, wasted their time. What should I do if I get sued for a time-barred debt? You have a few options, but the best thing you can do is make sure you appear on the court date or you will lose the suit. Once in court, you can use the time-barred defense, show your paperwork that proves the statute of limitation has run out, so the case will be dismissed. Beyond that, you have three clear options. Pay nothing. You should understand that the debt will negatively influence your credit score for 7 years, but with no court judgment against you, you don't have to legally pay. B, if your conscience gets involved, you can reach an agreement with the debt collector to pay the full amount or partial amount to settle the debt. It's funny they said that if your conscience get involved, like if you have a guilty conscience around the debt itself, then you can reach an agreement. Either way, make sure the agreement is in writing and signed by both parties before making the first payment. Or C, make a partial payment on the debt, which would be the least desirable choice. In many states, making a partial payment restarts the clock on the statute of limitation and may allow the debt collector to sue for the full amount. Very important. Now, is there a statute of limitation for court judgment? Yes, but be careful waiting for it to expire. The statute of limitation on court judgment ranges from 3 years in Oklahoma to 21 years in Ohio, with the most states somewhere around 10 years. The judgments are easily renewed, so chances are that eventually you will have to confront the judgment and pay it. Be aware, the states allow interest to collect on judgments until the debt is paid off. The interest ranges from 4% above Fed, Kansas, to 14% South Dakota. So know where you're at and how they can affect you. What if I can't pay a court judgment against me? Court judgment are a bad thing and should be avoided at all costs. If the debt collector is aggressive, and we've never heard of one who isn't, they will go after anything you own that has value. Depending on the laws in your state, the creditor could go after your home, car, boat, property, or even that 66-inch flat screen in your living room. If they can take it and sell it for the money they're owed, they will. At the very least, they can put a lien against those assets, meaning you can't sell what you own without settling up with the creditor first. And this happens. Does debt leave my credit report after the statute of limitation? No. A delinquent debt stays on your credit report. This is why it's important to get credit restoration help, because you can get it removed from your credit report beyond the statute of limitations anyway. However, it's just good to know that the debt is not going to leave after the statute of limitation, not just going to fall off. It stays on your credit report for 7 years unless you go about the dispute process and get it cleaned up, regardless of whether the statute of limitation has expired. That delinquent debt loses impact over time, but it does remain there for 7 years. So how can you verify the debt is really yours? If you get a call from a debt collector, never assume the debt they are trying to collect is legitimate. Remember, that's why I said alleged debt. Alleged. Do research, make sure you own it, and the statute of limitation hasn't expired. Your first step is to insist on the debt validation notice. Like I said, from the debt collector. Ask the debt collector for their name, company's name, street address, telephone number, professional license number. Then ask the company to mail you a validation notice, which details how much you owe and the name of the creditor seeking payment. The validation notice must be sent within 5 days of when the debt collector first contacts you. You have 30 days to dispute the debt. Now, when you receive something, it's important to get them to validate it as soon as possible, because they must send it within 5 days of when they first contact you. And you have 30 days to dispute the debt in the validation notice. It is wise to have your credit report available when you receive the validation notice so you can compare the information between the two and determine if the debt is yours. And you're looking for any errors. If there's certain errors, certain flaws, then it may not connect to you. So how does the FDCPA apply to debt after the statute of limitation expired? Well, the FDCPA, that's the Fair Debt Collection Practices Act. The Fair Debt Collection Practices Act are the laws basically that debt collectors have to operate under, and they oftentimes violate the FDCPA. And with that being said, you can use the FDCPA to your advantage in all of the situations related to debt collectors. All of this is based on the FDCPA. So how does the FDCPA apply to debt after the statute of limitation expires? Well, it says that you still owe the debt collectors can still try to collect, but they can't violate provisions of the FDCPA. In other words, they can't harass you, threaten you, misrepresent the amount owed, claim that you'll be arrested, etc. If the debt collector does pursue payment of the debt, you can send a cease communication letter that stops debt collector from contacting you. The letter should be sent via certified mail so there is a record of the debt collector receiving it. If the debt collector violates terms of the FDCPA, contact your local attorney general office, the Federal Trade Commission, or the CFPB and file a complaint. So these are people or entities in your toolbox: the Attorney General Office, the FTC, and the CFPB. Simply put. And you also can sue the debt collector for damages and be awarded up to $1,000. So there's many cases where they don't follow the law, they're doing things unlawfully, and now you have the right to sue and be compensated as a result. So this information came from In Charge Debt Solutions. So I got to give credit where it's due, incharge.org. But hopefully this answers your question. Share this with somebody who you feel may benefit. I've been getting this question a lot lately, and I said, okay, I want to record a thorough explanation and breaks this down so you can know what your state looks like in terms of the statute of limitation, what the rules are behind it, how not to put yourself in a bind or agree to pay a small amount and reopen that statute of limitations all over again, and some solutions if you find yourself in this situation. If you need assistance with taking your credit to the next level, I got you. Whether DIY or done for you services, I have it, so I can assist you. And if you find yourself in a situation that's centered around you being summoned or whatever the case may be, have solutions there as well. Can get you connected to the legal team if in the event that you have some type of FCRA violations on your report. Pretty much, if I don't do it, I have connections who do, who can position you to do what's most beneficial to you. Mr. Smith, signing out. Salute.